Hello, everyone, and welcome to Immigration Talk Show. I'm your host, Napasa, and thank you so much for joining us in this session, friends. I'm really hopeful that you're going to benefit a lot with this session because we're going to be talking about a very urgent situation, a topic which needs to be addressed. So stay with us. And before we head on with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. That said, friends, let me tell you that you can also join us in this session, and that you can do by commenting wherever you're watching us. Yes, please also tell us where you're joining us from. It'll be very nice to know that about you. So we are live right now on YouTube and also on LinkedIn, Facebook, X, and find us on Instagram. Follow us, friends. Thank you so much. So I hope you're ready for this session because we are going to be speaking about SEVIS terminated or visa revoked. Did you forget to register as a foreign national? That's right. We're also going to speak about registration for aliens and also touch up on the SEVIS terminated and visa revoked. A very, very important, a timely topic, and you must have seen a lot of recent updates and the executive actions that have been taken on many foreign nationals actually, and especially students. So many students out there are finding it very hard when you talk about service terminations or even their visa revocation. So, to help us get to know better about this topic, the situation, what's happening, and what to do next, we have none other than a very familiar face who keeps joining us, and I'm very happy to have her back on our show. None other than Attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. Thank you so much, Prashanthi, for joining us today. I hope you're doing good today as well.
I am. Thanks, Tabasa. I'm doing well.
Thank you. I know the situation is not very great out there, especially for students, and we keep hearing news about student visas being revoked. I think it's very intense, the situation for many foreign nationals out there, especially students. What do you have to say? What can they expect from this session today?
So we're talking about two things today. One is, of course, and both are equally important. One is we're talking about hundreds of students receiving visa revocations as well as SEVIS visa termination emails as well as SEVIS terminations. So they're getting an email from the Department of State saying that their visa has been revoked. And they're getting an email from SEVIS saying that their SEVIS has been terminated. This pretty much um, renders them out of status immediately as of the moment that their SEVIS has been terminated. If they only got an email from with a visa revocation, then that does not terminate their status, but most people are receiving both. And it's possible that if you did not receive a visa termination, that maybe you did not receive it, but your visa, I mean, if you did not receive a SEVIS termination, it's possible, and only a visa revocation, it's possible that you may not have received the email yet, or you may not receive it. You have to go to your SEVIS and check yourself, or have your DSO check whether the SEVIS has been terminated or not. It's the SEVIS termination that causes a problem for your status. So we're seeing hundreds of people, a lot of Indian students receiving this kind of email. Um, and Generally, these are people who have undergone minor problems in the past, maybe a misdemeanor. Uh, and even if those misdemeanors were, um, even if they were not finally convicted of anything, they were only charged, they're still getting uh, their service is still being terminated. Or it could be that they have a DUI or some kind of a traffic violation, where it's not a ticket, but more like a criminal violation. But as I said, even people who are not convicted of anything, but only charged with something, but finally not convicted, are receiving these kind of emails. So, and also for petty offenses. In addition to that, in addition to the SEVIS termination problem that is now raging through the US. We are also wanting to advise people on registration. Now there's a registration was always there, but it was more a passive requirement from USCIS. Now they've made it an active requirement. If you're more than 14 years of age, you have to be registered and fingerprinted. If you are not a US citizen, that means that applies to permanent residents as well. But you may not be required to register if you've already been fingerprinted as a non-immigrant. Um, and so we'll dive into more into who has to be registered and who doesn't have to be. If child is over is just turned 14, most probably they've never been fingerprinted, because children under 14 are not usually fingerprinted even if they're permanent residents. So they will have to be now registered and fingerprinted, and then they will give you proof of registration. So that's the two topics, and both are equally important, that we're going to be, breaking topics that we're going to be talking about.
Yes, very. Thank you so much. We are absolutely ready to get to know more about this, and thank you so much, Prashanthi, for joining us today. I'm looking forward for a very informative session. So I'd quickly say hello to Desi Wanderlust. Thank you so much for joining us on YouTube. And if you haven't as yet subscribed, friends out there, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And you can also join us in the show by calling us on this number. And the number is 425-436-6335, and the access code is 988-888. So you can join in and have a conversation with us, maybe ask your question to Attorney Prashanthi Reddy directly. And here we go. Prashanthi, I have questions for you. So let's start off with this first one that I could ask you. If you can explain, what a SEVIS termination means and how it immediately impacts an F1's legal status in the US.
So SEVIS is a document that basically gives you status as a student. The status of a student is maintained via this SEVIS portal, which is managed by your school and also managed by ICE. Usually, a SEVIS termination happens because the DSO does it, because you have not been maintaining status. Maybe you didn't take classes, or didn't take the required credits that you need to, in some other way have violated your status. But this SEVIS termination that we're seeing right now is slightly different. DSOs, in fact, are not even aware of the terminations. They are becoming aware when they do random checks, because they're required to do checks every month of everybody's SEVIS status, and they are coming to know only once they do these checks that it. So that's a little unusual, considering the fact that it's usually driven by DSOs. Here, they're not even aware that the SEVIS has been terminated. So that's something to keep in mind. Once your SEVIS is terminated, you're pretty much out of status. There's really no grace period. So that's how it affects you as a student. Yeah, so we can discuss more later on. And there's lots to
Yes,
discuss.
absolutely, we will. Yes, I know, and it's really shocking because when we have been reading the news and all that, it's saying that students didn't even know, and they're having a normal day in life where they're going for their classes or maybe even doing the exams and their OPT, and suddenly they realize that their visa have been revoked and no notification beforehand, and they suddenly find out. It's crazy what the situation is for so many foreign students out there, and we'll discuss more for sure. So, Prashanthi, yes, let's move ahead. And if you can tell us, are we now seeing a trend, where minor infractions like traffic violations or even late CVIS registration are triggering visa revocations?
Yes, we are, and that's the problem. As I was just saying, we are seeing instances where people who have a DUI are getting SEVIS revocations. People who have been accused of DUI, or we've seen shoplifting cases, um, mostly DUI and shoplifting and other traffic infringements. There was another case in which we saw that a person had an accident and they called the cops, and the cops arrested them instead of treating them as a victim. So we've seen that as well happen. Um, so, I mean, often CVIS violations, CVIS terminations happen due to some mistake by the DSO, by some administrative issue. But here it's just happening because the students have some kind of a minor infringement. As I said, either a shoplifting case or a DUI case or some other traffic incident. And in many instances, this has happened many years ago, and they've already, it's a petty offense. None of them are more than, most of them that I'm seeing are all petty offenses. So there's a petty offense exception, and never before have students been, has the student, even you can even get a green card if you have a only a misdemeanor, because there's a petty offense exception in the law if you've been, convicted of only a misdemeanor. But here we are seeing serious terminations. We're seeing students being sent back from the US and their status terminated simply because of petty offenses and misdemeanors. And often, as I said, it's been several years since they've been convicted and they've already served their sentence. Or in many, many cases, they've actually not even been convicted. They've been released as innocent and they have not admitted to any wrongdoing. They have not plead guilty, and they're still being sent. The CVIS is still being terminated, and their visas have still been, revoked. So this is something that we're seeing for sure.
It's crazy. I mean, how and why are they digging up the past, and trying to poke it all now? It's crazy. We still do not know, friends. I know this is the question many of you all out there watching us are also having. Like,
Well,
yeah,
Nipasa, we know why they're doing this because the present administration wants to be strict on immigration and they want to
yes,
remove as many people from the country as possible, and that's why they're doing it. And they're using this as an excuse, really.
right.
So, yes, that's what they've become very, very strict in their vetting process. This is
It's
part
true.
of the plan, part of the executive order signed by Trump. So, it's part of that.
Yes, it is.
That's why it's
Yes, it
happening.
is. And we'll just have to face it, friends. I think
And I think it started off, I think, Nipasa, it started off with the student protests and started off like that. But now, even people who have never protested or never broken any rules but have other infringements in place are also getting serious terminations.
yes, it's so true. Thank you so much, Prashanthi, for highlighting that and for making this much clearer a picture for us today, right now. And I know there's so much more to ask, to get to know. So let's move ahead, I would say. So coming to our questions, Prashanthi, if you can also tell us uh, what are the legal consequences, if a student forgets to register or update their information as a foreign national under F1 status?
Well, this is nothing to do with the present situation, but in general, uh, you're supposed to update your CVs. The DSO is supposed to do that. You cannot really, you don't have control. You cannot edit your CVs information, but the DSO is supposed to update it. Sometimes they do forget to update it, especially when there is some kind of a change of address, change in employment during your OPT time. Um, Maybe you're in H1B cap gap, maybe your OPT is over, whatever change there is, change in the registration for classes, maybe you're taking less number of classes. So if that change hasn't been made, then it's possible also that the service can be terminated. And the result of a service termination is that unless you file for reinstatement and it gets approved, you are out of status, and it's possible that unlawful presence might start accruing, which will lead to a ban of 3 to 10 years. And we can talk about unlawful presence more a little later.
Yes, absolutely. But at this moment, I think we should quickly say hello to Desi Wanderlust once again and take up his comments. So he's saying, hello, myself, Venkata Ravi Teja Reddy Kanduri. I am an international student with F1 visa. I came here on 27th August 2022. OPT started on the 2nd in September in 2024 in on on February, and STEM OPT on, sorry if I'm taking it right. I think this is November and December. So yes, on 2nd of December 2020. Sorry, 2nd of, sorry, 12th of February 2025. It's
February,
confusing me. I'm
February
so
12th,
sorry. Yes.
yeah, 2025.
2025 of February.
Yes.
Yes, my court date is on the 21st
But
of
there's no
April
question.
this month.
So, is there a question?
Yes, and my CVIS is already terminated and visas revoked. I was changed with no tag, no insurance, and possession of marijuana just brought from gas station, less than 1
Charged.
gram pack
Yeah, charged.
or even opened.
Okay. So, what's the question?
What is the,
Please ask your
yes, please
question
ask your
so
question.
that
Yes. He's saying his court date is, I think he's asking what should he do. His court date is on the 21st of this month, and his CVIS is already terminated and visa is revoked.
while he has to go to court and see if he can, I mean, possession of, the problem is even though it's legal, marijuana is legal in many states, as per the state, as per federal law, marijuana possession is still not legal. So you have to be, I mean, that's what maybe happened, unfortunately. So from the immigration point of view, possession of marijuana is not legal. So maybe you could, I mean, obviously you need an attorney to represent you in immigration court, and maybe you can use the petty offense exception since I'm presuming either you have not been charged, there's no criminal charge, but it could be that this could be a crime against moral turpitude and they can still deport you. So it's important that you get an immigration attorney to help you with your case. It really, the judge will now decide whether you should be removed or not from the US, or whether to reinstate your status.
Right. Thank you so much, Desi Wanderlust, for your question. I mean, for your statements, we'd rather have a question if you have any. But otherwise, yes, if you do want to have a consultation with Attorney Prashanthi Reddy, you might as well call her up. You can call her on a number 212-354-1010, or email Attorney Prashanthi Reddy at prashanthi@reddyesq.com. And definitely go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy. So, coming to our questions, Prashanti, this is if a student visa is revoked, do they have any legal remedies or grace period before self deportation is expected?
Um, well, there's no official grace period. However, if you're active, and in many of the instances, we see that it's being remains active for the 15-day period. So if in during that 15-day period, they allow you to, they don't lock the CVIS, so they allow you to transfer and file for reinstatement. So when your reinstatement is actually in process, you will be allowed to continue to go to school, but you will not be, if you're on OPT, you will not be allowed to continue to work. But you can remain in the country. So CVIS, reinstatement is something that you should definitely look into. But as I was saying, unlawful presence is something that might come into play. Unlawful presence is pretty much if you stay in the country for more than 6 months after your status has been terminated, then you're considered to be unlawfully present. And therefore, if you leave the country and try to come back, you'll be barred from entering for a period of 3 years. And if it's more than 6 months that you're unlawfully present, then you may be barred for a period of 10 years. So if you try to go out and get a visa, you will not be granted a visa. Though I must say, unlawful presence does not apply to students who have DS, so who are in duration of status because they don't have an I-94 a particular date. It's only DS, so duration of status. But there recently was an update on the USCIS website where they said that students in DS status can also start accruing unlawful presence. But something said on a website is obviously, even though it's the USCIS website, is not the law. They have to follow the law, but it shows their intention is what they intend to do, and they intend to follow this path, and then we'd have to push back saying that it's not the law, and in order to make it the law, it has to go through a comment, go through a notice and comment period, and put into the Federal Register, which has not happened. So that's something to keep in mind with reference to unlawful presence. So even if you file for reinstatement, your unlawful presence clock may not stop ticking, but we might be able to argue that there is no such law. So otherwise, you're expected to depart immediately. Um, and you can get a reinstatement I-20, leave the country, and then come in on a new visa as well, because most probably your visa would have also been revoked in the present situation. Um, the other option is also, I know it's not part of the question, but just to get it out there, since we're talking about the remedies, if you get termination on your SEVIS, there are several class action lawsuits that are being filed. You can join one of them, and you don't have to pay a lot of money. Starting your own case and filing your own individual lawsuit against USCIS, you can join one of the class action lawsuits and pay less. And so that's that. And then if you file that, it's possible that the judge can at least order that, pass an order that um, that ICE does not come and pick you up and remove you, at least until the court decision is final, until they decide. So they can put a temporary stop on any removal or deportation proceedings against you. So you may not have to worry that ICE will come and deport you. So that's another consequence, of course. Not only are you out of status, but it's possible that an ICE agent might pick you up and then do an expedite removal and send you back to your home country. So that's also a possible consequence, and their possible consequence is detention. If they don't do expedite removal, they can detain you, and the worst case scenario, they can detain you outside the country, where we've seen people being sent to El Salvador, which you don't want that happen, but that's the worst case scenario.
Right.
So I think we've talked about possible consequences and remedies for STEM OPT termination.
Right, right. Thank you so much, Prashanthi, for taking that up. And, now I would like to touch up upon our second part of our topic, the registration of aliens. And I think we should go ahead with that. And if you can clarify, the key differences between immigration registration and immigration status, especially under this new executive order 1459. And why is it important for foreign nationals to understand this distinction?
Uh, yeah, so I mean, the key differences is one is status and one is you're registering to show USCIS that you're in status. So your immigration status affects your right to remain in the country, work, study, or just status based on your I-94 or based on your whatever your status is based on your green card, maybe. Immigration registration is you're required, it's an obligation under the Immigration and Nationality Act, Section 262, which was not enforced previously. At least recently, it has not been enforced. You are required to register your presence and provide biometrics and personal details. And this applies regardless of what your status is, meaning even if you are not in status, even if you're undocumented, you're required to register, and maybe That's what they're looking for. They're looking for undocumented aliens, and they're hoping that they'll come forward and register so that they can then remove them from the country after finding out where they are. So that's the purpose, maybe, of the registration, and they also want to keep track of where all the non-immigrants, non-citizens are in the country, so that they can easily have access to them and take action if they need to. Um, so it's under the executive order, the recent Trump executive order 14159. As I said previously, it was a passive requirement. Now they're saying that it must be affirmatively completed. Um, unless there was prior fingerprints taken because some benefit was given to you, and or while you entered into the country, if you entered legally, fingerprints are always taken. So unless that happened, you're required to do the fingerprints and the registration.
Okay. Thank you. Thank you so much, Prashanthi, for taking that up. And hello to Sony. Thank you so much for joining us. We'll take up your question very soon. Just stay with us. And let's go on to our next question that I have, Prashanthi. If with the introduction of Form G 325R, 325R, and online registration options, how should unregistered individuals, particularly those without prior contact with immigration agencies, how can they navigate this process to ensure compliance with the INA 262?
Before, there was no way for them to ensure that they're compliant, and that's why it was a passive requirement. Now, in order to make it easy for everyone to comply, they've introduced a new form, G325R. And so this, you have to go to your online, you have to open an online account on myuscis.gov and then fill out this form. And you have to do this. You can either do it, of course, you can do a paper form or you can do online, but they prefer a paper form. Once the form is done, then you schedule biometrics with a USCIS field office or ASC office where they take biometrics. Then you retain confirmation of the submission and the appointment record, and then you will finally be given proof that you are now registered. So in order to comply, you go online or you can do it in paper. And if you want to do it online, then you should do that by opening a MyUSCIS, opening an account on myuscis.gov. Who needs to do this? Individuals who entered without inspection, foreign nationals who have never been fingerprinted or had to do biometrics before, minors who are turning 14 within 30 days of their birthday, they have to do it because minors are not required to submit fingerprints before the age of 14. And this, their parents have to do it, and their parents will have to face consequences if it's not done. Of course, Canadians who entered without under visa exempt rules, where they're not required to fingerprint at the port of entry, if they remain over a period of 30 days, then they need to do it as well.
Okay, okay. So, friends, I hope you're taking notes, and these are new important points that you have to keep in mind. And that said, Prashanthi, also, if you could tell us, given that the registration is now like a civil and criminal enforcement priority, what are the legal consequences for individuals who unintentionally fail to register within the required 30-day window, especially minors turning 14 or even Canadian visitors?
Well, the civil penalties could be you have to pay up to $500 for first offense, or if it's a higher or a more willful non-compliance, if they see that as that, you could be paying a higher sum than $500. Of course, it could be a criminal penalty, that is a misdemeanor charges with up to 6 months imprisonment or a fine, or both. It could, of course, have adverse immigration consequences, such as denial of, any future benefits, denial of visas, um, denial of adjustment of status or asylum, So these are things to keep in mind. US to waive the penalties if the failure was not willful. And for minors, as I said, they're still required to register, but enforcement is typically directed at their parents because they're minor.
Right. Thank you so much, Prashanti, for taking that up. And there you go, friends. If you have your 14th birthday coming up, I think this is another thing that you could keep in mind. And do not forget to register. That said, friends, I hope that you're resonating with our content and especially with all the information that Attorney Prashanti has shared with us. Do not forget to register. I mean, subscribe to our channel, and our handle is at Immigration Talk Show. Check us out. We are not just on YouTube, but also on LinkedIn, Facebook, X, and also on Instagram. So connect with us. Yes, it's very important. And I do hope that you're also hitting that bell icon so that whenever you have discussions like these, you're notified and you do not miss out on any important updates or information. So thank you, Prashanti, also. So coming back to our questions, Prashanti, if you can also tell us in cases where individuals were previously denied a visa or immigration benefit but submitted fingerprinted forms listed under 8 CFR 2641A, are they still considered, registered under the INA, and how should they verify their status?
Yeah, so if an individual is previously fingerprinted, for example, they had they filed adjustment of status, or maybe they filed asylum, they filed an EAD with biometrics when biometrics were required for EAD, or any other thing, advanced parole, I-751, and if they completed their biometrics at any ASC, application support center, they are likely to be considered to be registered even if the underlying benefit was denied. So they will not be required to register again. Of course, how do you verify whether you've ever been fingerprinted? Maybe you don't remember. I mean, you could request a FOIA, request your file under FOIA, Freedom of Information Act, to see whether you've been registered or not. Call USCIS and request confirmation of registration, and give them the section INA 262, or use their online account if available to view past appointments and submission records. If you already have an account, that might appear on your USCIS, my USCIS account. So these are some ways of finding out. And yes, absolutely, registration is counted even if your case was ultimately denied.
Okay. Thank you so much, Prashanti, for giving us that information, for sharing that with us as well. And coming to some of our, I think we should address Sony's question. Sorry, Sony, for keeping you waited for so long. He's saying, I am a TPS holder for 9 years who came here in F1 visa, and I want to go back to F1 visa. What will be the procedure?
Once you're in TPS, that's a temporary protected status and does not allow you to change status to anything else. It's not, uh, since you don't have an I-94, it's not considered to be a valid status. So you can't change status to an F1 by remaining in the country, but you can leave the country and then come back on an F1 visa. But of course, getting an F1 visa once you've been out of status here is difficult. So you have an uphill task ahead of you.
All the best, Sony. I hope you can figure out, and all the best, I would say. So, this next question I have for you, Prashanti, is how should individuals, who entered without inspection or those with unclear registration histories assess their compliance risk and also take proactive steps? And particularly if they may not have received the I-94 documentation or biometric confirmation also.
Yeah, so people who entered without inspection may not have their biometrics done, because usually most people who entered legally will have their biometrics done at the airport. You all know that at CBP, we all have to get our fingerprints taken, even US citizens. So first thing you have to do is assess if any prior biometrics appointments was ever completed for you. It's possible that you have an asylum case, even though you came without inspection, and biometrics were done at that point of time. If you're not sure, submit the G325R anyway, um, and explain that the lack of formal entry documents in the cover letter to show that you don't have them. Or, as I said, you could request a FOIA under Freedom of Information Act. You can file a FOIA with both USCIS as well as CBP to see if there were any prior interactions with either of them. And of course, consult with an immigration attorney um, before you do any of this, because of course, when you do 325 CR, the registration, the other consequences of it could be that USCIS ICE now knows where you are and they can come and pick you up and remove you. So it's a catch-22 situation, following the law and then the consequences of following the law. Something that you should at least be aware of.
Thank you so much, Prashanthi. And these are new updates, friends. I really hope that you're keeping yourself updated. It's very important because every day there's a new thing coming up, and you should know, especially whether it's going to affect you or not, or somebody, from your family is going to be affected by it or not. So keep yourself updated always, and for that we are also here. So don't forget to register. Don't forget to subscribe, and our channel, our handle is at Immigration Talk Show. Also hit that subscribe button, the bell icon as well, so that you will be notified when we have discussions like these or any new updates. Okay, and also check us out not just on YouTube but also on LinkedIn, Facebook, X, and on Instagram. And that said, we do have some more questions from our audience, and I think, controller, if you can display them please, we are going to address each one of them. So yes, I think, Prashanti, what do you have to say? I mean, it's crazy. Every day there's a new update, and we don't know what is going to happen.
I think it's important for people to watch shows like this, consult with attorneys. I mean, shows like this are invaluable because, free advice is being given to you. Otherwise, you'd have to pay a $200 consultation or a $150, whatever it is. The consultation fee is, it's very difficult to get an attorney to speak to you free of charge because they're very busy. So these kind of free information sessions are very, very useful for you. But if you need a one-on-one consultation, definitely this is all general information and may not be helpful for your particular case because every case is different. So you should, get a opinion from an attorney as well, especially in this climate because things are changing so rapidly. You want to make sure that you are maintaining your status.
Absolutely, friends. I do hope that you are keeping yourself updated. Thank you, Prashanti. We totally appreciate, you coming to our show every week and sharing all these important information with us. And now let's take up our questions from our audience. So, Control, if you can please show us. Yes, Shaukat here is asking, I am selected as Master Cap, but my degree conferral is May 31st. Can my employer file LCA before 31st of May and file the H-1B petition later in June after degree conferral date, or has to file even LCA after 31st May after degree conferral date? Please guide. Mean for LCA degree is needed or not?
No, for the LCA, you don't really need the degree. You can file the LCA ahead of time, even before you get your master's degree, and then file for your H1 once you have your master's degree in hand. But remember, even if you do not have the actual degree in hand, as long as you get a letter from your school showing that you have completed all the requirements towards your degree, you're still able to file a master's cap H1B petition.
For your question, and thank you for your question, Shaukat. Yes, do not forget to register, subscribe to our channel. Sorry, my mind is working only with register today because we are speaking about such a topic. Registration is very important for all foreign nationals, and There we go. Don't forget to subscribe to our channel if you're resonating, if you have your answers, especially all you viewers out there watching us in different platforms. Go to our YouTube channel. Our handle is at Immigration Talk Show, and do not forget to subscribe to our channel. Thank you. And let's go on to our next. This is from Krish. He's saying hi. Thank you for sharing this information. Will this consideration for specialty occupation come into play for H1B renewals as well, as opposed to new H1B applications? To elaborate, if my job description needed a general qualification like MBA previously, as opposed to something specialized like MBA in finance, could this affect the ability to get a successful renewal? Thanks.
Yes, absolutely, because the new H-1B regulations um, came into play as soon as the regulations were published. That is in January. So as of that date, any H-1s filed, whether it be an extension or a transfer or an amendment, they fall under the gamut of that new H-1B regulation. So you gave a good example. Previously, uh, even if the case was approved, now it may not be. Even previously, the rules were pretty much very similar with reference to specialty occupation. Not much has changed. So even before, if you said just MBA instead of MBA in finance, most probably um, you would get an RFA, and if you didn't, maybe it was just out of luck. But definitely, you have to be careful now. If you just ask for a general MBA, you should ask for the job should require a specific MBA in a specific major in order to qualify for a specialty occupation.
And that said, you should check out the definition of specialty occupation, and very much changed this year, and keep yourself updated with that regard as well. All the best, friends. And now let's go on to our next question. And this is from Elon Musk 2050. Okay, very interesting name. Do we receive
Oh,
emails or only employer will be notified? This is information regarding lottery results.
uh,
Okay.
you don't receive emails as the beneficiary. Only the employer will receive an email saying that there is some change in their My USCIS or some update in their My USCIS website. And then they go to their website and then they go through their registrations and then they have to check whether which ones have been submitted and which ones are still in the selected, um, which ones have been selected and which ones are still in the submitted status. So your employer gets an email, but not individually, an individual email with reference to each registration they've done, but you don't get any kind of email at all.
I think that is a very important update as well. Thank you, Prashanthi, for taking that up. Now let's go on control to our questions from our Facebook groups. So if you can display them, please. So this is from an anonymous participant asking, "Hello everyone, me and my wife are currently in the US on B1, B2 and looking to apply for H1B lottery. I have warehousing and logistics experience of over a decade, whereas my wife has experience of more than 5 years in US accounting. Need help in placement and H1B lottery applications. Can anyone help?"
Well, lottery applications are already over. So maybe this is an old message, I'm not sure.
April 3rd.
But you could file April. Oh, okay, so it's already over. You should file for next year's lottery. Obviously, being on a B1, B2 is not possible until next year because it'll be next October before you, even if you get selected in the lottery, before you can file a H1 and you have to maintain your status until then. So I would suggest that you leave because you can't continue to stay on a B1, B2 and you don't want to violate your status unless you plan to move to an F1 or something like that. Otherwise, you'd have to leave and then come back next year, and then file for registration and then file for a H1. Or you don't have to come back. You can file for a registration while you're outside the country, and then if you get picked, then come back next October on a H1 directly.
Hmm.
With reference to warehousing, logistics experience, accounting experience, it depends on the kind of job you get, but it's possible to get job in accounting, and that is a specialty occupation, or you could do a financial analyst job. I'm not sure what you could do with warehousing and logistics. Maybe operations research analyst is a possibility, but I think you'd have to take a one-on-one consultation with an attorney to
Absolutely.
go through all your documentation and see what jobs. Well, actually, you have to first apply for jobs and then go through this process rather than the other way around.
Yes, absolutely. Because you have to have a specialty occupation, a job waiting for you. So I do hope that you can find that job and get your calling to the US again, and that too on an H1B. All the best. And now let's go on to our next one. This is also from an anonymous participant. Hi, has anyone filed I-130, I-485, and I-765 recently for their parents? What's the wait time?
If you file it recently, obviously you're not going to know what the wait time is because it's definitely over 6 months. But yeah, I mean, I've seen varying wait times. Last year we saw that in some instances it was just taking a few months, maybe 4 to 6 months. In some instances, it was taking 12 to 18 months. So I would say anywhere from 4 to 18 months would be your processing time. And the problem is now they've made USCIS has made interviews compulsory, and we've received an email from USCIS stating the same. So whenever there's an interview, you can always expect that the processing time goes up because the field offices have very few interview appointment dates, and the interview date may not be for a few months. So it's something to keep in mind.
Yes, thank you, Prashanthi. And folks, do not forget to subscribe to our channel. And if you have any more questions from your end, please comment. You can just comment wherever you're watching us. We are live right now on YouTube, LinkedIn, Facebook, and also on X. So thank you all your viewers out there, especially on X. I can see a lot of viewers. Thank you so much for joining us, for watching us. Please feel free to join us also on call. Any one of you can call us in and ask your questions. I know you have many questions, especially with regard to the topic of discussion today. So our number is 425-436-6335, and the access code is 988-888. So yes, thank you, Prashanti. Now let's go on to our next one. This is also from an anonymous participant. Is it true that DS 160 won't be updated from May 1st? And what about before that? Can someone please clarify it? I heard only uni name and CVIS ID are changed before May, but my course is different too. Please, can someone clarify this?
I'm not aware of any changes with the DS 160, so we have to wait and see what those changes will be. But I did want to mention that we have some breaking news also. Every day there's breaking news, right? So today at 9:58 a.m. we did get an email from USCIS basically saying that, and I'll just read part of it to you. USCIS will begin considering aliens' anti-Semitic activity on social media and the physical harassment of Jewish individuals as grounds for denying immigration benefit requests. This will be immediately effective. So they're going to look at um, social media posts to see before they approve any kind of benefit that you're requesting, whether it be USCIS, Department of State, you're filing a H4, you're filing a H1, you're filing a visa. Um, they will look at your social media posts, and they will keep that in mind before they give you any benefits, including if you apply for a green card. So please be careful about what you post on social media because that will be taken into consideration as one of the factors before they give you any kind of immigration benefit.
There you go, friends. And social media truly matters now, especially what you post. So also social media matters for us as well. So why don't you connect with us? Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And also check us out. We are not just on YouTube, but also on LinkedIn, Facebook, X, and also on Instagram. So just on on X we are Immi Talk Show. Otherwise we are Immigration Talk Show, and that is our handle. Thank you so much, everyone. Thank you, Prashanti, also.
I also wanted to you to keep in mind that any kind of post where you're disagreeing with the government's enforcement priorities, or you're disagreeing
Yeah,
with what they're doing with reference to immigration, or with reference to public policy, or with reference to their foreign
yeah.
policy, whether it be Gaza or somewhere else, could be taken as a negative, could have a negative impact on your immigration status. So be careful while you're posting.
Yes, I think now even sharing what you think is no longer that safe anymore. So please be careful. So take care, and think before you post anything or share anything. It might be very you may take it very lightly, but not everybody watching you, who is probably judging every step that you take. It may not be that light for them. So take it seriously, even your social media. And now let's go on to our next. This is also from an anonymous participant. I am applying it to college and I got my I 120 for me and my family. Do I have to pay the SEVIS fees for everyone or just me?
Uh, I'm not aware of how the service fee works, so let's go to the next question. I don't want to give information that's incorrect.
Okay, sure. Let's go on to our next one. This is from Roma asking, hello, are there success cases of extended B1 visa adjusted to F1? I am now on 6 months extension and looking to adjust to F1, but scared to do so as I have extended my B1. Please enlighten. Thank you so much.
You are allowed to file for a change of status from a B1 to an F1, and there is also premium processing for change of status to an F1, um, and they will respond within 30 days. So you can do it. You're allowed to, as long as you have not violated your status.
All right. Thank you, Roma.
You also have to, of course, you have to keep in mind that the start date of your school. Make sure that you're able to get the approval by that time, and make sure if you're not able to, then the DSO is willing to postpone the start of classes for you, or maybe put you for the next semester, re-enroll you for the next semester. So you have to be in touch with your DSO with reference to these F1 change of status applications, because the processing time is not in your hands, and the DSO has to be agreeable to postpone your enrollment if you don't get the F1 on time. But luckily, with premium processing, at least we don't have to worry too much about that.
Right. Right. Thank you so much, Prashanti, for taking that up. And Roma, thank you for participating with your question as well. Folks out there, do not forget to check us out. We are on YouTube and also on LinkedIn, Facebook, X, and on Instagram. So check us out and do not forget to subscribe to our channel. Our handle is at Immigration Talk Show, and on X, we are Imi Talk Show. So check us out and stay in touch with us. Also, do not forget to check out Attorney Prashanthi Reddy, and you can call her up or message her, or even email her in case you have some urgent questions, or you definitely need a one-on-one consultation. Then call her up on her number. Her number is 212-354-1010, and her email address is prashanti at reddyesq.com. And definitely go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. So let's go on to our next question. Hi everyone, petition I-130 and I-485 filed parent of US citizen. Please need to ask, do I still need to get an extension if I 94 is about to expire? Thank you in advance.
That's a good question. But if you've already filed the adjustment of status and if you have a receipt, then you don't have to apply for extension of your I-94. And also, it's difficult to get a extension because now that you have an immigrant petition pending, they will not give you an extension of your I-94 on your B2 or B1 or whatever it is that you've come on, especially if it's an F1 or a B2 or B1. So, unless the case gets denied, then of course you have to leave immediately, but otherwise you are in status.
For sure. Thank you so much, Prashanthi, for taking that up. Let's go on to our next one. With that, I think we have taken up all of our questions from our Facebook groups. And yes, Daisy is back again with this question, but we have already addressed to address your question. So thank you so much, Daisy, for you know asking your question. In case you missed it out, Attorney Prashanthi Reddy has already taken it up. Check this, episode again. You can. I think you were not here when she answered that. But yes, all the best. And Prashanti, maybe before we leave, if you can leave all of our folks watching us right now with an end note and things to keep in mind, especially with this current situation.
Yes, especially with reference to STEM revocations, I think we have to be. I mean, there's no good answers. I think you should contact your attorney. Every scenario is different. Every case is different because your goals are different. Some people don't mind leaving the country after they, get their degree. Some people want to stay on until they graduate. It might be possible to stay if you want to. If, for example, you're graduating in May, you might just have to stay for a month more. So maybe filing a reinstatement is makes sense for you because then you'll be able to at least graduate because you can go back to school while your reinstatement is pending. But if you're on OPT, filing for a reinstatement doesn't allow you to continue working. So maybe that is not a good option for you because you have to look at the unlawful presence rules and be cautious about it, just in case they apply to you, as I was talking about that earlier. So every scenario is different. I think it's important to talk to an attorney, talk to your DSO. There's no one fix for everyone because as everyone's situation is different. So definitely talk to an immigration attorney and your DSO to find a solution to your problem.
Absolutely. It's one of the most important things to do right now because it's getting confusing, especially with, everyone getting shocked about their status, their visas being revoked with no notifications prior. So anything can happen, but best is to contact your attorney if you have one. It's well and good, especially for your family. Go consult with them. They'll update you and check on your statuses as well, and it's very important to keep all of your documents updated. So all the very best, and also do not forget to contact attorney Prashanthi Reddy in case you need an attorney for yourself to consult with your case. So the number is 212-354-1010. You can call her up, or you can email attorney Prashanthi Reddy, and that is you can do by emailing her at prashanthi@reddyesq.com, and go visit www.reddyesq.com to get to know more about attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. Thank you so much, Prashanthi, for joining us today. It was a very, very informative session on this very serious and critical topic, I would say, especially for all students out there. I hope this was very helpful. So thank you once again, Prashanthi.
Thank you.
Have a good day. Friends out there, do not forget to subscribe to our channel once again. And let me remind you about that. You can do that by just hitting subscribe button and also hit that bell icon so that whenever we have discussions like these, you are notified and you do not miss out on the latest updates, which are very crucial, especially at this point of time, where wake up to new notifications, new rules every day. So, all the best. And also, you can check us out. You can also contact me, my WhatsApp number, my phone number. Maybe you can call us or call me or just message me whatever questions you have so that I can take them up and address them when we have webinars like these with attorneys. And my number is 408 335 6444. And you can also email me. My email address is nipa@staffingly.com. With that, thank you so much, each one of you, for joining us. But stay tuned because we got more webinars lined up and also a very, very important one in just uh, next hour, I would say. So, 2 p.m. Eastern Time, tune in again for another very important discussion. Thank you and have a great day ahead.